Hello everyone. I'm Anne Putz. I'm head of short courses at the Courtauld, and I'd like to welcome you to the first of a series of short conversations on the relevance of the law to art history. And these are intended to be of benefit to prospective curators and art market professionals among our undergraduate and postgraduate students, and of course, also of benefit to our lovely short courses participants, many of whom have a really abiding interest in the art world and all of its operations. And with me is Dr. Kyle Leyden, lecturer in architectural history at the Courtauld and a former barrister. When you specialized in contract law, among other things, and you also taught contract law. And you have, of course, also been a long-term advisor, legal advisor to heritage bodies in Northern Ireland and in Dublin. And we are joined by Stephen Coopersmith, who's founder of the Coopersmith Law Firm in San Diego. And Steve, you're also a collector, a former board member of the San Diego Museum of Art, and you are a long-standing supporter of our program showcasing art history. So, Steve, to start us off with, your firm has been tasked to draw up the art and cultural property law guide for California. Would you tell us briefly about this project and sum up for us what areas this very wide field of art and cultural property law governs? What is governed by this? And what disputes does it address?
Sure, absolutely, and thanks for having me. I just by way of background, my firm handles mostly business and corporate litigation issues, and my sort of introduction into art law came really into cases that I handled for art galleries and collectors and the like. And so my interest and then growing practice in art law really sprang from an organic sort of method of really handling real world cases. And so over the course of gaining sort of knowledge and gaining thankfully some understanding in the world that we do handle art law and a sort of a growing recognition of our work. I was asked by the Chambers and Partners, to me, very prestigious organization, to prepare their art and cultural property guide. And those guides are generally updated yearly. What we are planning on doing is doing sort of essentially updating it by year, and then doing the next year, and that's what we're doing for this year, an article that sort of talks about a particular trend in art law, and then the next year sort of updating that guide and answering additional questions that the Chambers guide or rather gives us. And then the intent of that really is to provide sort of a real world practice guide for both practitioners, in-house counsel, and the like, to really understand kind of what are actual real issues that practitioners are experiencing, and what are some of the regulations that are and trends that are going on.
And these are, Steve, these are global, so different areas will be covered. So you will have one for Europe, you will have one for individual areas in Europe, you will have one for the USA, and then a specific one for California. Is that right?
Yeah, that's right. And in fact, we decided, because California is really particular in the way that it approaches art law issues, and we'll get into some of that perhaps maybe in this lecture or another lecture. But certainly in California, there are particular issues. And because we're California lawyers, and our firm is local to California, we wanted to sort of focus on that, and rather than cover the field of the USA. But there are other states or other jurisdictions that the art and cultural property guides are being written, and certainly in really many other countries throughout the world. And I think it's a wonderful exercise. I've spent some time being able to read some of the other jurisdictions, and it's fascinating to see any person's any art lawyer's take on kind of what's going on and different trends. So I try to follow that as well.
And I think one of the benefits of this transatlantic conversation that we're having now is to bring home one of those, what to me seems to be a key challenge of art law, is that it has to operate across different national and even regional legal frameworks. And that is, it's actually really fascinating to dip into the Chambers and Partners guides to see the kind of different emphases. So between you, I wonder if you could just, for the benefit of our prospective students, if you could just sum up some of the sort of key areas that art law is responsible for. Sum
Absolutely.
up some
So,
of those.
so for there are so there's a myriad of issues that art law covers really so many different kinds of things. And as an art law practitioner, you have to be you have to have a multidisciplinary approach to this. So just by way of example, and to some extent get experts involved when it's something that you don't handle or you don't know, and to know when you don't know something. So for example, commercial law it dominates. I mean, people think art law is this esoteric, very, very sort of high level thing. It often is. You're dealing with sort of issues of commerce, of art galleries and contracts, and and contract terms and all of those kinds of things. Intellectual property really is there's quite a few issues of intellectual property and corporate law. People don't really think about that for art law, but corporate law about ownership of a company that perhaps owns the art, or internal disputes or fraud issues, and sort of criminal law. There's so many different kind of aspects of art law, and perhaps Kyle can share a little bit more from the UK perspective.
Yeah, no, absolutely. There's actually no aspect of the art world which doesn't in some way touch upon a legal aspect, right from the creation of the art, whether that art is actually obscene or whether the artist has committed a crime, right through to the sale of that art and all the things to do with contract law, through to the theft of that art, should it be stolen, and finally through the cultural protection of that art, if it is considered to be of national importance. How we actually keep that art within a particular jurisdiction is very important as well. All of these issues, and I'm sure that's what we'll be dealing with in this particular video, all of these issues have come to the fore, particularly in the last 20 years. And what we've seen happening within this area is that art law has actually extended its remit quite significantly, particularly in the UK in the last 20 years. So that really no practitioner within the art world, be they in the commercial art world or indeed in the cultural heritage world, none of those practitioners can really ignore the law anymore in the way that perhaps they felt they could do previously.
That is so interesting because we see now a sort of an emphasis, a focus on art law that certainly wasn't there when I was a curator or working as a sort of curatorial research fellow and working within museums. And so
Absolutely.
now
And
is the
even
moment.
yeah, even within law, that
Mm.
attitude it was sustained for quite a while, actually. Famously, one American jurist said that art law was equivalent to horse law. Yes, there are laws dealing with the horse, but there is no such thing as horse law. And in the same way, there is no such thing as art law. And I
But
think that is a position which is increasingly hard to sustain, I think, within the modern art market, particularly.
Yeah.
But I think that also even comment on that I think that there were art lawyers for years and years and years. They just didn't call themselves art lawyers. They
Mm,
were they were outside general counsel or transactional lawyers or litigators and they handled, maybe their clients were art galleries or museums or the like. And I think that all of those things where it's sort of now congealed into this mass of many different topics, and to call it. And I think to the point of was it Simon Frankel actually who called it, who said something about horse law, right?
indeed, yes.
Equine law, and you could say that because you could say that there is a body of law that relates to that. And so I think similarly that's the way that really art lawyers are now approaching it.
I mean, with my historian's hat on, I would like to understand why the art market, the art industry has historically been so badly regulated or unregulated, even compared to other fields. I mean, clearly, art is not just another form of property. Is that one of the reasons? Can I put that to you both?
Well, absolutely. If I can kick that one off, and I think to answer that question about why, certainly historically, the art market has been so under-regulated, I think you need to look at two issues: one legal, the other sort of socio-political. Historically, first of all, art was treated by the law as pure personal movable property, which was not considered to be systematically important to either economies or indeed public welfare. So the acquisition, movement, and sale of personal property was very much seen as being outside the scope of legal regulation as a private matter between individuals. That's particularly the case in jurisdictions with a written constitution, such as Ireland, where I was originally in practice, and of course, the United States, where there is specific constitutional protection of private property, but it is equally apparent within the UK. The valuation of art objects is also extremely subjective and, as we all know, subject to wild fluctuations across time, meaning that setting any objective legal fair pricing benchmarks against which to judge the art market transactions that are going on and prevent abuses, that's virtually impossible in that context. And I think that's what you were getting at, Anne, when you said about art objects being not quite the same as a bar of gold or an antique piece of furniture. In terms of socio-political matters, I think you also have to acknowledge that historically, the commercial trade in art was entirely controlled and operated by a very small economic and cultural elite, which overlapped significantly and importantly with the ruling political class. That meant, firstly, that the art market was largely governed by unwritten customary rules of etiquette, which this group felt confident would be adhered to on threat of expulsion from that social grouping, that threat being in itself enough to secure compliance. Secondly, that meant that there was no political pressure to impose state oversight, as the political class had an interest in maintaining a free market where consumer protection and transparency were matters of self-regulation in the interests of that cultural elite. And I think that distaste, particularly for transparency, remains a crucial aspect of the art market even today. Confidentiality, as we all know, remains a core principle of the art market, protecting collectors' identities and also, more importantly, perhaps, preserving dealer leverage. A huge volume of art is still sold outside of public auction rooms and private arrangements facilitated by auction houses, specifically in order to avoid revealing the identity of vendors and purchasers. So any system of regulation would dismantle a system of secrecy, which really has been seen and remains very much a core of the art market's core mechanics. Finally, from a political standpoint, maintaining a free art market has always been in the interests of successive governments and economies. London, New York, and Hong Kong, for example, developed as great centres for the art market principally because of the freedoms they provided for the sale of art objects. So any increased regulation would put that critical source of state revenue at risk. So as a result, even today, attempts to regulate the art market, I think you could at best say, and I'm not sure if Steve will agree with me on this, but at best was seen as sort of fragmentary, and they certainly seem to be very uneven indeed.
I totally agree with that. I think really what the way to look at it is that the modern sort of structure of regulatory that deals with disclosure and transparency and commoditization, where something is you can copy something like a set of regulations that apply to many different things, really doesn't. It's very difficult to apply it to the uniqueness of the art market. And I wanted to make two quick points, which is, so historically, one thing when I was looking into this is that actually in the 18th century, the large auction houses, I mean, it was almost entirely unregulated before that, but the auction houses, and some of which, like Sotheby's and Christie's, are still very prominent today, really actually were at the forefront of trying to regulate the art market for their own purposes, for their buyers' purposes, for their consigners' purposes, for a lot of different reasons. But that was the first sort of reins in, and to some extent, on attribution and valuation and authenticity and provenance issues, sale condition kind of terms, and all of those kinds of things that ended up really, really, as many of the regulation structures that we try to impose today. The other thing that I wanted to just say is that the sort of the strangeness and uniqueness of art and the personal and emotional nature of art in that, the market has always prized things like exclusivity and insider access and opaqueness and privacy. And that, I can say as a longtime litigator, those are the absolute opposites of the things that the law tries, whether it succeeds or not, tries to sort of provide. And those are the difficulties, I think, of regulating it in a world. And we'll get to the technology issues. That's a whole different ball of wax, I would say.
Thank you. I have another really complex question for you both. So, Steve, I read your cultural guide, Art and Property Guide, with great interest, and I was really struck by the definition of art. And I wonder if you could both talk about this. What is the definition of art in law, both in the UK and in America? And I have lots of follow-up questions on this, so I'll let you take that away.
Well, shall I start again? And
Sure.
yeah, again, you've asked what seems on its face to be a sort of very simple question, but in reality, the nature of artistic practice, basically what Steve's been talking about there, the nature of artistic practice and the sort of protean nature across time of what we consider to be an art object makes the question of what the law considers to be art actually quite complex. I mean, obviously, art historians have pondered the question of what precisely art is for millennia. And I suppose any art historian worth their salt would be able to mount a solid philosophical argument as to why one object is art and another is not. However, the law is rather more prosaic. And the problem here is that the law really requires clear objective rules when dealing with the distinction between what is art and what is not art. In particular, there's been a solid move in the courts, certainly in the UK, to avoid at all costs forcing judges to make decisions on artistic merit or the particular meaning of works of art. So as a result of all of that, the UK actually has no single definition of art, and instead it very much adopts a functional approach. And we've developed a number of context-specific definitions applied to certain objects or works for specific legal purposes. So, for instance, for copyright law, under Section 4 of the Copyright Designs and Patents Act, an artistic work is defined as, and I quote, a graphic work, photograph, sculpture, or collage, a work of architecture, or a work of artistic craftsmanship. The first part of that is terribly useful. The phrase artistic craftsmanship brings you straight back to the question of what is artistic craftsmanship. And needless to say, the courts in the UK really have struggled to define what a work of artistic craftsmanship is over the years. But they have generally utilized a test of practical function versus aesthetic quality. The work should be original and not mass-produced, nor should its dominant use, as far as the courts are concerned, be functional. In addition to that, the courts generally apply a test whereby they ask whether the general public would objectively view the object as having as its principal purpose aesthetic enjoyment. That is a far from perfect definition, and only represents one definition of many that the courts have in relation to copyright law. Criminal law is more interested, for instance, in the idea of art as personal property. Tax law with the means of how objects have actually been produced in the first place. So all of that is to say, there is no one definition of art in the UK, and the courts still very much debate what precisely it will encompass. Needless to say, this is becoming an increasingly live issue globally, but particularly here in the UK, with the development of digital art, and more especially the kind of emergence of AI art, none of which can be considered entirely original, because unfortunately with AI, it's scrubbing the internet for other people's work and creating something out of that. So these debates about what is and what is not art continue to be very live in the UK. And it's a very interesting area, I think, to watch going into the future, how we deal with digital art and AI art. So I'm
So
not sure what Steve makes of all of that in the
ve-
US.
very much the same, for sure in the US. I mean, there's on a very different topic. There's a famous quote from the US Supreme Court Justice Potter Stewart, who was talking about a very different topic, but he said, "I know it when I see it," right? And I think that that's what I would say about in an overall, sort of idea. I think we're getting into that with the digital art for sure, because I think, so for example, US copyright law requires human authorship. Well, what does human authorship mean? And there's a case several cases, but one particular case that's going on right now where an artist, and a cartoon artist's work was sort of was then taken by online platforms, by AI platforms, and they could sort of change that. And it touches on issues of fair use, but it also touches on what does it mean to create art. So, it's one thing to say an artist, like we'll perhaps get into the issue of Richard Prince and the Warhol case, but it's one thing to say an artist took this art and modified it, and what does that mean for fair use issues? It's a totally different thing to say an AI, chatbot sort of took this piece that was available to it, in its database, and then modified it, based on inputs and somebody's request. And so those things about what is art. So in the U.S., for example, in U.S. copyright law, it comes really the closest, I think, to saying, look, it has to be an original, it has to be fixed in a tangible medium, it has to be pictorial, graphic, or sculptural, and then there's something called the Visual Artists' Rights Act, VARA, in the U.S., and that's the closest that I think we come to the idea of moral rights for artists. I know that the UK and the EU have much more sort of robust moral rights issues that go back, quite a bit of ways. We're a little bit behind on that possibly for good reason. But under VARA, a work of visual art is really what's covered. And not only that, but it has to be a work of visual art that's into some of the protections only apply where it is a noted work. And like, what does that mean? And so you can rely on experts and sort of the art market to sort of guide that. But it is a very, very loose definition.
That's so interesting. And Steve, when I read your guide, I was really discombobulated by the inclusion paintings, drawings, sculptures, or an original work in glass. Okay, question mark here. But, and to my astonishment, no original prints. And you've got beautiful one there behind you. No bio art, no land art, no installation, no performance. And this requirement to create an original work that is fixed in a tangible medium, does that mean you cannot copyright an idea, a concept? This is so confusing
So
to
let
me.
me take that issue first. So the idea, you can't copyright an idea, right? So absolutely not. But there are other protections that apply to ideas. For example, if it's an idea that is original and in a technological or other kind of sense, you can patent it. And I'm not a patent lawyer, but there's a whole body of law that applies to when an idea can be protected from someone taking that idea. A trademark is the mark of it, right? And that also has a protection in a sense. Going back to some of the other areas, it has to be in most U.S. law, it has to be tangible to be protected as a work of art. But and that this is a very big proviso, is that there are other regulations that may apply to, for example, to archaeological issues or historic architecture, or there's a Mills Act in California that relates to protection of sort of sort of architectural heritage, and in return for sometimes a tax abatement or property tax reduction. There are Native American protections, and there are cultural heritage protections that many jurisdictions, both federally and statewide, have. And so those are some of those other things that you mentioned are protected, may be protected under other regulations. They may not just be dealt with in a copyright sense, but that doesn't mean that they're not protected necessarily.
Absolutely. And there is a similar sort of situation in the UK with regards to performance art in particular. Performance art itself, the performance, unless it's a dramatic work, which is capable of being copyright, the performance itself is not subject to copyright, but rather is subject to what are called performers' rights, which is a separate provision of the same act, which actually allows you to protect your rights as a performer of a particular work of art. But it isn't strictly copyright by any means at all.
One other quick thing that I want to say, the uniqueness of the U.S. is we have the Bill of Rights, and the First Amendment is so central. I believe very strongly in it. It's being challenged many times a day sometimes. But the First Amendment is so important in the U.S. and the sort of the fabric of our society. And so art, a lot of different performance and other sort of expression. And there's an entire body of law that is so vast that there's no way that we could even approach it here. But the First Amendment law really does apply to many of those things of expression, freedom of expression. So yeah. I'll put that.
That's great, and we'll come to that when we look at the rights and responsibilities of the artists again. But I just wondered if we could sum up, Kyle and Steve, the particular challenges that the art field has for law. If we could sum that up and then bring this first part of the conversation to a close.
Yes, well, again, I think I'll kick that one off and say that we've already dealt with some of the sort of challenges of the art world. The first being, obviously, as we've discussed at length, the special nature of art as an asset. It really is not the same as personal property. It has national cultural importance. It is unique. It can be subject to an obsessive wish to own a particular thing. These things do not simply arise in relation to normal property, be it a gold bar or a piece of antique furniture. So the unique and very special nature of art really is a challenge for the law going forward. In addition to that, there's a big challenge of balancing artistic innovation against censorship and protecting copyright. Because as soon as you start censoring artists for being obscene or enforcing copyright, there is an argument that what you're actually doing is stifling artistic innovation. And those are many of the arguments that are being used, particularly in relation to AI art, which on its face seems to breach copyright law in scrubbing the internet. However, are we, by enforcing that copyright law, creating a chilling effect on artistic creativity? That invention of new artistic technologies is probably the absolute salt mine, the rock face of what future developments are going to be about and how the law reacts to the development of AI and also NFTs. Obviously, Damien Hirst having a very interesting experiment a few years ago about whether art is about owning a particular item or whether the ownership of a thing, regardless of what it is what people are actually buying. That's a really interesting question, whether people are actually buying an object that they want to own or whether the actual ownership itself is enough, whether or not the painting is hanging on your wall. You also have the growing practice in auction houses of enticing buyers. This is a big problem going forward for the art world. Wealthy collectors are now kind of hunted in the wild by auction houses. They're invited to Christie's where they come in and they're plied with champagne and they're shown around by a director and they're basically told that this item, they must have it in their collection. technically speaking, auction houses don't have any duties whatsoever to buyers because their contract is obviously with the person selling the object. But given the fact that they are now enticing buyers in such forceful ways, the law will have to deal with that and actually start really encroaching on this idea that auction houses do not owe any duties to people buying from them. It's removing that idea of caveat emptor. There's an increasing cross-jurisdictional element to all of this, which again I think we've touched upon. And the big question that's going forward is the use of artworks in organized crime and money laundering. The courts have become very aware, as have governments, particularly in the last 10 to 15 years, of the art market really being the last Wild West of financial movement across borders, which has not been sufficiently regulated. And as a result, the criminal use of art to fund organized crime and in money laundering is being clamped down on and will be increasingly regulated going forward.
Yeah, so Kyle touched a little bit about NFTs, and I want to kind of talk about that interesting example, because there was a moment where it seemed like everyone all the time was talking about NFTs, where that was all that not just art lawyers but collectors and all kinds of people were talking about. And there were very strong opinions about that. But that's a good example that NFTs were billed in some way as sort of this antidote to sort of fraud, because it's on the blockchain. It's solid. It exists. And you can show the provenance of it, and you can show the authenticity, and it will never change. And people,
of course, just to say that in tandem with that, NFT was also a way to make a digital piece of art unique, because otherwise, how is a digital piece of art unique? It seemed to be the solution to that question as well.
It seemed to be, and everybody was getting on this NFT bandwagon. But what people found was that first of all, there were massive energy problems of actually creating and minting the NFTs. Caused like an enormous amount of energy, usage. That's one. Two, they were like anything. And I was trained originally as a prosecutor, so I can tell you that you come up with anything and someone will figure out a way to criminalize it, right? And so there were fraud and scams and lots of ethical issues, but also things like where it was billed as the sort of antidote to fraud, and also kind of authenticity problems. There were something called link rot, where, I mean, we've all experienced where a link that someone sends you, you go back and look at it, and you're like ready to look at that link, and the link no longer exists for whatever reason, because the website was changed or whatever. And that was happening in the NFT world, even for the blockchain. That link rot was, the server went down or the link breaks, and the art, poof, disappears. And so, that issue, that was a challenge. The other thing I'll just say is, and I'll just bring up this example, and you can look it up for any viewers. You can look this issue up. But there was this. I was consulted for a little while on a concept called the Artist Pension Trust, and it was a collective. It was an interesting collective of artists. There's the idea to provide for artists, sort of. Maybe their market goes up, maybe their market goes down, maybe they can't sell, over a period of time. So the idea was for a collective of artists to sort of pool their art, and each artist would gain, on any art sale, would gain money off of one part of that sale, and then the pool of artists would gain money off of the rest of the sale. And then there would be a portion for the company itself to sort of provide for marketing and overhead and all this other stuff. It became a morass. And you can look it up. There's a New York Times article, Artist Pension Trust, and you can look that up about the morass that ended up happening, where the company stopped communicating with the artists. There were 2,000 artists all around the world. So there were an enormous amount of jurisdictional issues. There were trust and estates issues where artists died and what happened to their rights. There were massive storage costs involved. So the company, that company that owned the trust, really, and you can learn about that, ended up trying to pass off some of as alleged, tried to sort of pass off the costs of the storage onto those artists. And so there were all kinds of issues with that. And that sort of comes full circle back to the multidisciplinary aspect of art law, but also the challenges that when you create new ideas, that you have to try to fit it into all of these different categories and all these different regulations. It creates a problem, but it's fascinating in the search.
It is fascinating. I think you've both, between you, really identified AI, NFTs, digital art as one of those areas where the most developments will come down the line, I think, or will have to come down the line. And Carl, you've also mentioned the use of art in money laundering, that kind of protection, criminal and against criminal misuse as sort of trends in art law. Just to end this first part of our discussion, Steve, I wondered what you would say makes for a good art lawyer. What kind of personal and professional qualities would you look for in someone who comes to you and applies for a job in your firm?
I think that curiosity is incredibly important. I think flexibility is important because of as we've described, the really the changing nature of both technology and as art law is applied to that, and law in general regulations are applied. I think that sort of the ability to handle a number of different to issue spot is what it's called in law school, to issue spot a number of different sort of problems or issues that occur in any given fact pattern. You could have 7 different areas of law or more that really in one sort of fact pattern that you get from a client, prospective client in some way. I think sort of so that this multidisciplinary fluency or ability to sort of pick things up and to understand them, and I'll come back to, I think that curiosity is, and to me is a measure of really the people that I respect the most in the world and life are people who are curious about all kinds of different things, whether they know it or whether they don't know it. And that I think for an art lawyer in particular, because of course, as an art lawyer, you might want to have, it would be beneficial to have a true interest in art and art history and all of those things. You don't need to have it, but it would be useful. But a curiosity of really like when you see something, you want to look it up and you want to understand it. And I think that those are qualities that I think would make a good lawyer in general, but I think in particular in the art law field.
That sounds lovely. We'll pause our conversation here and pick it up again when we talk about the artist.